In the adoption legitimation stage, government officially accepts a particular course of action from among the alternatives produced in the formulation stage. Adoption means choosing. A policy statement is adopted. Policy statements must be adopted by government institutions because, at least in American society, only government is recognized as having legitimate authority to impose binding decisions on society. This legitimacy is conferred by a legal constitutional process. Policy statements may take several forms. Legislative enactments, or statutes, or ordinances, or formal laws made by representative assemblies such as the United States Congress, a state legislature, or a city council. Formal rules of decision-making usually govern legislative processes. Executive orders are issued by chief executives ostensibly to manage or organize the administrative machinery of government, but they frequently serve to authorize new policies or changes in existing policies. For example, in the early 1980s, President Ronald Reagan issued an executive order, number 12291, requiring all federal agencies with regulatory authority to submit all proposed regulations to the White House Office of Management and Budget for central clearance. As a result, the number of new regulations promulgated by regulatory agencies dropped dramatically, affecting the government's ability to protect air and water quality, workplace safety and health, food and drug safety, among numerous other responsibilities. In 2001, President Bush signed an executive order limiting federal funding for research using fetal stem cells to those stocks of stem cells already in existence. Superficially, the order was an effort to manage how the National Institutes of Health awards grant funding to researchers. The policy implications for scientific research using stem cells were significant, however. In addition to the president at the national level, some state governors have the authority to issue executive orders as well. Administrative rules are enacted by government agencies such as the Environmental Protection Agency, Occupational Safety and Health Administration, and the Food and Drug Administration, among many others, under their regulatory authority. The United States Congress establishes these agencies by passing what is known as enabling legislation. These statutes create the agency and assign it a regulatory mission. Such enabling legislation, however, rarely provides detailed guidance to the agency as to how it should implement its regulatory mission. Instead, agencies are provided with administrative discretion to identify problems needing their attention and are given formal rulemaking authority to establish regulatory standards. The formal rules made by federal regulatory agencies have the coercive and binding force of law, just as if Congress had passed a statute. Formal rulemaking by federal agencies is sometimes referred to as a quasi-legislative process for this reason. However, Congress can always rein in an agency's formal rulemaking authority by revising or amending its enabling legislation. Some state agencies have formal rulemaking authority as well. Court decisions sometimes serve as policy statements. However, only a small percentage of all court decisions would qualify as policy statements. Trial court decisions almost certainly would not. Even most appellate court decisions would not qualify. However, the percentage seems likely to increase at higher levels of appellate courts. Decisions of the United States Supreme Court frequently serve as policy statements. If the court decision has the potential to substantially change or alter an existing policy or practice, we say that it has policy impact and can be considered a policy statement. Brown versus the Topeka Board of Education in 1954 and Miranda versus Arizona in 1966 are two good examples. In the Brown decision, the court ordered racial integration of public schools, while in the Miranda decision, it mandated state and local law enforcement agencies to inform suspects of their rights under the Fifth and Sixth Amendments, not to incriminate themselves, and to have an attorney present during interrogations. Informal policy pronouncements are statements indicating direction or intent made by high-ranking government officials such as the president or cabinet officers at the federal level, a governor at the state level, or a mayor at the local level. For example, suppose the president declares that his administration will pursue an even-handed policy with respect to resolving the Israeli-Palestinian conflict. Setting aside the question of what the president might mean by even-handed, the policy pronouncement is informal in the sense that it was not articulated by formal legislation, executive order, or any other document resulting from a formal procedure. Informal policy pronouncements are no less authoritative than more formal statements such as statutes, executive orders, administrative rules, or court decisions. However, they are arguably more flexible and subject to easier modification.